All right, well, let's continue our conversation now with Douglas Guilfoyle. He's a specialist in international law and maritime security at the University of New South Wales, and he's joining us from Canberra. Douglas, we've reestablished our connection with you. Glad that you're back with us. Let me ask you, countries engaged in conflict have long used maritime blockades as a method of warfare. From your vantage point, how does this blockade compare to other recent examples, and what are the broader implications at this stage?
Okay, well, as I said before when we were cut off, and as you've just said, international law acknowledges that during an international armed conflict, blockade is a potential tool of economic warfare. It has a number of important limitations. One is that neutral trade that doesn't connect with Iran should be allowed through, and the Americans have said that they'll allow that to happen. Another important limitation is that for a blockade to be legal, it must be effective and it must be applied against all vessels. So we've only heard so far of one vessel successfully making it through the blockade. So that sounds like an effective blockade. But the third critical point is that it does not have the consequence of starving the civilian population or denying them access to, say, vital food and medicine. Now, that's obviously been the criticism of Israel's blockade, for example, of Gaza. So we have to see how this blockade plays out in practice. But so far, it would appear that the Americans are, as it were, doing this by the book.
Douglas, we're at this moment now where there was a ceasefire that was agreed to, and after that happened, a blockade was imposed. Does that mean that the ceasefire is technically over?
Well, there's no law about ceasefires per se. Right, you can agree to a cessation in a temporary cessation in hostilities, but the moment you have a blockade on, you're effectively saying that you are again engaged in an international armed conflict. And it's not just me saying that; it's the United States Supreme Court saying that in its case law around the U.S. Civil War. That when you declare a blockade, you are acknowledging that you are in an armed conflict with a belligerent party. So it's difficult to see that a ceasefire and a blockade can coexist.
Douglas, I want to look at some of the ramifications that might be happening going forward. If ships in the Strait, if they're flagged down by U.S. vessels in order to be searched in the coming days, do they have to submit to this search? Are they legally obligated to do so?
Well, that's an interesting question. There's not... Whether a neutral vessel is legally obliged to submit to a search, I suppose, is an open question. But if they don't submit to the search, if they resist boarding, then they do run the risk of becoming a legitimate target. So I would say it's highly advisable for any neutral vessels to submit to search when hailed.
And Douglas, obviously, the Strait of Hormuz, it's a very narrow waterway. How much concern is there right now as to how close American ships and IRGC Navy vessels may be to each other going forward? And what kind of a risk of confrontation is there at this stage between the two?
Well, that's a question for a military specialist, perhaps, rather than a lawyer. But what I would say is there's not an obligation that you enforce a blockade really right in close against enemy ports. And that's one of the reasons you might ask foreign shipping about their intended destination. So my understanding is that the blockade line is likely to be enforced at a wider point in the Gulf, where there's at least sort of 200 nautical mile width to the body of water rather than in the narrowest regions. And that would obviously be the safest way to do it for all shipping.
All right. Douglas Guilfoyle is a specialist in international law and maritime security at the University of New South Wales. He was joining us there live from Canberra. Thanks so much, Douglas.